So Kalev, you and I know that after people have been in a relationship for 3 years, whether it's in a marriage or a de facto relationship, it ends up being an equal split of relationship property, doesn't it?
Yes, that's right.
So if they haven't got anything in place, potentially they're in trouble. And this, when it comes to Section 21 agreements, otherwise known as prenuptials, prenuptial agreements.
Yes, now I just should correct you, Bridget, because when you say they're in trouble, it's actually one person's in trouble.
That's right, yeah.
One person's doing very well. So prenup agreements, that's more of an old term, and it's short for prenuptial agreement, like pre-marriage. But technically, the Section 21 agreements, and it's referring to Section 21 of the Property Relationships Act, they don't actually have to be done before the marriage. They can occur at any time during the marriage. But the reality is that if you leave it till after the relationship becomes qualifying, a qualifying relationship, namely 3 years together, then if you think about it strategically, if you're the party, the moneyed party, the party with a lot of wealth, you've actually left yourself wide open, because if you think about it, Bridget, once I've lasted 3 years with this multi-millionaire, I've hit the half jackpot, haven't I? So you can imagine the conversation, over dinner and champagne, the wealthy person saying, honey, would you mind signing this? You're effectively giving away $5 million in my example. So why would you?
Exactly. So tell me more about the what should be in these Section 21 agreements.
Okay, so the main purpose of these agreements is to contract out of the equal division rule under the Relationship Properties Act, and typically we will have it in a situation where it may be a second marriage or a second significant relationship where there may be one party who has accumulated a lot of wealth. He or she may have children from a earlier marriage, and quite reasonably wants to protect that, because I guess once bitten, twice shy. So the purpose of the agreement is to confirm and clarify and provide certainty at the start of this relationship that all the stuff here, share portfolio, holiday house, that's my separate property, and regardless of what happens between us during the course of our relationship, that will remain my separate property at the end of the relationship. So it's to provide certainty. You might wonder, well, what are the other circumstances where we might use a Section 21 agreement? Another situation is that people may be going into a marriage, and they may be buying their first home, but one party might be providing 80% of the funding, and another party providing 20%. So the prenup, or the Section 21 agreement, might recognise those contributions and say that in the event of this relationship coming to an end, then we take those respective shares out when the property is sold. But it's all up to you what you put in there. I have seen Section 21 agreements that say, well, that unequal sharing will apply up until we hit year 7 or year 10, and then it falls by the wayside. So there's the ability to be creative and match whatever particular needs and desires those parties to that relationship want to have, taking into account their circumstances.
So how much is this going to cost our viewers, Kalev?
Well, geez, she's always putting me on the spot. And I'm sure once I say this, there'll be other lawyers chiming in saying, oh, I can do it for cheaper than that. But let me give a range. So I would say for your basic Section 21 agreement, probably about $2,000 plus GST. But at the other end of the scale, where there may be trusts and partnerships and share portfolios, overseas assets, you might be looking at as much as $8,000 plus GST. Okay. But I think for the typical couple, you're probably landing between $3,000 to $5,000 plus GST.
Okay. So who pays for it then?
Well, if it was me, being asked to do it, I'd say you pay for it.
So I hope your negotiation skills are good. Then.
Yeah, but typically I think more often than not, parties will share those costs. So there'll be a lawyer who drafts that agreement, and you may be aware, Bridget, because it's such a significant document, that each side needs to be independently advised. So there'll be another lawyer's fee out there. So really, it's up to people. But my suggestion is that 50-50 is reasonable. Or if you've got a disparity between wealth, then the wealthy one who's most motivated to get this valuable piece of paper to avoid coming to litigation lawyers like me down the track, then they should pay.
Yeah, absolutely. So what are the fundamental things that need to be in that agreement?
All right, well, as I've mentioned, it will say this is what we appreciate and accept as separate property for each side. And sometimes they may have some shared assets already, and that can be demarcated in the agreement as relationship property. And obviously, self-evidently from the way I'm talking, the first criterion is it needs to be in writing. Second criterion, it needs to be signed and witnessed by someone separate from the parties.
And not someone who's part of the family.
Yes. We also need the solicitors to sign the agreement, and they sign a special certificate, and that certificate confirms that the lawyer has explained the terms and the effect of the agreement to the person before they've signed it, and confirming that the lawyer considers that they have understood it. An important part of these agreements is also that there's been disclosure. That's probably more important in Section 21A agreements, which are agreements that we can talk about on another day,
Right.
which are agreements where parties decide the divvy up of property after they've separated.
Right. Okay. So I've heard of instances where these prenups have been overturned.
Yes, that's possible. There is a specific provision in the Relationship Properties Act allowing the court to do that.
Interesting. So how can people get their prenups overturned? What sort of instances?
The first thing that everyone needs to understand, it's really difficult. What the benchmark is you need to show serious injustice. So that's the key words used in the section. And I should add that previously the word was injustice without the serious before it. And a few years ago, Parliament added serious in front of the word injustice, and that was because there was a perception out there that there was not enough regard being paid to certainty of contract. Because after all, the reason that you've done this is that you are agreeing at the start of the relationship, if we pull stumps on this, this is what's to happen. And in our society, contracts are regarded as important. However, having said all of that, serious injustice might arise where there's been a lot of pressure put on one party to sign that agreement.
So, for example, the night before they get married, for example.
Yes.
Duress.
Yes, you're on the money there,
Right.
Bridget. There is a case, quite a well-known case amongst family lawyers, where the male partner, I think a day or two before the marriage, had a prenup agreement presented to his bride-to-be, and I mean, everyone can imagine, you've got family and relatives, people flown in from different parts of the globe to attend this great event, and then one party says, look, by the way, if you want all this to go ahead, and you can imagine a bride, the biggest day of her life, saying it's not happening if you don't sign this. So in that instance, the Section 21 agreement was set aside.
So they end up getting married?
Well, they ended up getting married, but when the relationship ended, that agreement was set aside, and the ex-wife got a much more substantial share. So that's one example. There might be situations, and I'm just flying off the hoof here, this isn't a particular case, but there may be a misrepresentation where it's, look, honey, if you sign this, look, if we get through 5 years, I'm never going to rely on it. And in good faith, you've relied on that, and then you sort of hit year 7, and
it's all over.
It's all over, and they pull the pin. Then you may be able to persuade a court that that misrepresentation induced you into signing this, and but for it, you wouldn't have done so. So that's another example I can think of.
So how does the court weigh out whether they would set aside these agreements?
Okay, so we've talked about a couple of examples, duress and misrepresentation. So they will look at these circumstances around the time that the agreement was made, and then they will look at the circumstances now, and if it comes to the point where circumstances have so changed, you know, the Section 21 agreement was done when they were, you know, young, early 20-somethings, and then these people are in their 60s, you know, that duration, that is going to have an impact on the strength that the court gives to that contract. By contrast, you know, if it is, you know, 3 or 4 years, then the court is going to give a much greater emphasis to that value of certainty of contract, which is, you know, regarded highly in our society.
So what would be your takeaway for our viewers in terms of prenups?
Okay, so this isn't necessarily legal advice. The takeaway is that, you know, if you're starting to form a relationship with the person who could be him or her, you need to have that hard-headed conversation early on in the relationship before you move in. So do it early. It may be awkward, but that awkwardness is a lot less painful than not doing it and then involving, you know, lawyers and experts 10 or 15 years down the track.
And a whole lot of stress.
Absolutely.
Well, thank you, Kalev. That's been extremely important information that a lot of people, I think, know not a lot about, but they do now.
Yeah, well, we've just scratched the surface, but thank you very much, Bridget.
Thank you.